So do we have Patricio Rufino back there?
The interpreter is back, Your Honor. 1 second while I connect to the headphones.
All right, state your name.
Tu nombre,
Rufino Patricio Gavino.
Rufino Patricio Gavino.
All right, you were picked up and incarcerated on a domestic violence battery charge. They originally set no bond on that. Defense wished to be heard. I am, just for the record, appointing the public defender's office for all of the incarcerated inmates for purposes of their detained status. If I don't indicate differently, I have found probable cause on each of the arrest affidavits that were called.
Thank you, Judge. Marie Taylor with the Office of the Public Defender. Just be asking for a $500 bond. I believe this one's misdemeanor domestic. Mr. Rufino doesn't have really any criminal history to speak on outside of two misdemeanor trespasses.
State wish to be heard.
Yeah, just started.
Got it.
State wish to be heard on Rufino as far as an appropriate bond.
One moment, Your Honor, I'm sorry. Your Honor, the recommended bond is $7,500.
Okay. Well, this is what the court's going to do. I'm going to set a bond of $1,000. No contact with the victim, no return other than once escorted by law enforcement to retrieve any personal items.
Oh, wait, which case are we on? I'm sorry.
This is on Rufino.
I'm sorry, Your Honor, I gave you the wrong.
Is the state aware of anything different on that case?
I'm sorry, Your Honor, I was looking at the charge on the wrong case. Yes, Your Honor, 1,000 is fine. I was looking at the wrong charge. 1,000, Your Honor.
Okay. All right, so the court has set the bond and with the conditions. And can return, no return other than once to retrieve personal items. All right, thank you. Shaquila Benavides. I guess it's Miguel Benavides Shaquila. State your name, please. Oh, we need the headphones. State your name.
Aquililla. Miguel Ángel Benavides Aquililla.
Miguel Ángel Benavides Aquililla.
All right, you were picked up on the aggravated assault with a firearm. There was no bond set on that. For the record, you are apparently out on bond on 2 other cases. And one of them is a carrying concealed firearm. And one of them is an aggravated assault with a weapon. Both of those cases, the court is going to revoke the bond and set no bond until it's just, unless another judge wishes to establish one. As to this newest case, I will set a $10,000 bond with no return and no contact with the victim. Thank you.
Judge, is that for, so we have 2 charges? We have a 2021 CF 1570280. So we have aggravated assault with a weapon and aggravated assault with a firearm.
How about the new charges?
Yes, Your Honor.
I've only got one. Is it all in one case or is it different cases?
I think it's a typo on the,
Yeah, look like it was endorsed. The 13357.
Yeah, the
Okay.
yeah, the 6-5. Yeah. And this one. Yeah. I revoked the 2 cases he was out on bond for. And that's 0 bond until one is established in the future. And then I set the bond on the newest case at the $10,000 mark.
Okay, Your Honor. Thank you, Judge.
All right, thank you.
thank you, Judge. And just to confirm, the PD's appointed on the 2 that were revoked.
Yes. Since he's back in on those. And is it Leonidas Entre Martinez? State your name.
Leonidas Contreras Martínez.
You're here on a new charge of possession of cocaine, count 1, attempted destruction of evidence, count
Sí.
2. And count 1 has a $1,000 bond, count 2 has a $500 bond, which the court is staying. Apparently you are out on bond on 2 other charges of possession of cocaine. And in both of those cases, the court is revoking your bond and placing no bond until a new bond is established by the court.
Okay.
And I'll point the public defender on those cases if you're not already on them. All right, thank you.
Okay.
Is that all the Spanish or is there still one? No, this might be. Gonzalo Humberto Indez, he bonded? Okay. Is that all the Spanish? Okay, so we can excuse the Spanish interpreter.
Your Honor, are there any witnesses who need the interpreter?
I don't know if we have any, do we have any witnesses that we're aware of? Okay, apparently there are some, but we have not been informed that any of them need the interpreter.
Well, if the interpreter is excused, I will be leaving the office, so
Okay, any way of calling down and making double sure? Okay, before we release you, we'll make double sure that there's not any witnesses that need you. As soon as they let me know, I'll excuse you.
thank you very much, sir.
All right, Charles Trey. State your name.
Charles Shea.
All right, you were picked up on 2 counts. One is hit and run, failure to stop, remain at crash involving a death. Other is vehicular homicide. You also have a second case, which is a resisting officer without violence. On that case, which is the 21 MM822, you've got a $500 bond. On the felony case, you've got a $7,500 bond on count 1, and you've got a $15,000 bond on count 2. And before you came in, I indicated I was appointing public defender's office on all of these cases, at least for purposes of your jail situation. If you want to hire a private attorney, you know, that's something you'll need to take care of. Anything else? All right, thank you. And Vincent Williams. State your name. State your name, sir. Sir. State your name.
The judge is asking for his name.
Vincent Williams.
Okay. You've been picked up and incarcerated on a grand theft, 3rd degree, with a $1,000 bond. Court is going to stay that bond. You also have a second case that was on case number 21-15680. You've got a second case, which is 21-15682. That has robbery as a count 1 with an $8,000 bond, burglary of a structure count 2 with a $150 bond, grand theft 3rd degree with a $150 bond, dealing in stolen property with a $150 bond, receiving money from a pawnbroker under false identification, $150 bond, and false verification of ownership for a $150 bond. So you have 1,000 on one and a total of, he has one more case? Hold on. All right, and then there's a third case. The third case, which is 21 CF 15685. You have robbery with a armed with a weapon, count 1. It currently has no bond. We'll talk about that in a minute. Dealing in stolen property, count 2. Receiving money from pawnbroker, count 3. False verification of ownership, count 4, and petty theft, count 5. All of those, well, counts 2, 3, and 4 have a $150 bond. Count 5 has a $100 bond. Does the state wish to be heard on count 1 about setting a bond on that one?
Some type of bond.
On the armed robbery, Your Honor?
Correct.
We're asking for no.
Care about anything he had said more than
Defense wish to be heard?
something.
Judge, as to the case ending in 15685, we'd just be requesting a reasonable bond. It's not a punishable by life felony, so he is entitled to a bond. And I think that the kind of duplicative nature of these charges is gonna be, make it difficult for Mr. Williams to secure his release.
I just had a baby. You want me to do this?
So,
Be quiet.
so at this point, Judge, Mr. Williams is just asking for a reasonable bond, so that he can secure his release as to each of these cases.
Okay. Well, what the court's gonna do, and I realize unless some of these go away, it's gonna be difficult for him, or it could be very difficult for him to make bond at any amount, but
This is
court is gonna set a bond of $10,000 on the robbery.
wow.
Anything else? All right, thank you.
We have bonds, we have bonds on each one of your 3 cases here.
So all them cases I have bonds on.
We're here for 3 cases.
When you see all them cases, it's more than one case.
What's your question?
Do I have bonds?
You're not here on these cases. So for each one of the cases, it's just-
Yes, as a bond on all counts.
All counts I have bonds on
Yes, you
every
have a
single
bond on
count?
every count. Okay?
I don't have that in front of me.
Okay. Did we ever hear from downstairs? All right, we need Hertland, Gabriel, Sotojo. Sootoojopi. Did we ever hear from downstairs as far as any witnesses needing an expansion? Okay, we can excuse the Spanish interpreter. Apparently none of the witnesses need one.
Thank you, Your Honor. Have a good day.
All right, thank you. State your name.
Soto.
You need to speak up so we can hear you.
Soto.
What's your first name?
Milan.
Okay. You're here on a retail petty theft. You have a $500 bond on that charge. Anything else? All right, thank you. Have we able to get anything on this? Do we know who the private attorney case was?
Yes. But I think he was only, Urdu interpreter. We haven't done it yet.
Your Honor, is the court going to consider Mr. Joyce's case now?
Yeah, we're gonna call the Kyle Joyce case. Do we have Kyle Joyce back there? State your name
Kyle Joyce.
and state your name.
H. Manuel Hernandez, on behalf of Mr. Joyce, I filed a limited appearances for the purpose of this initial appearance, Your Honor.
All right.
At this time.
You were arrested on domestic violence battery. They set no bond on that. I assume you're here to argue as to what would be a reasonable bond or conditions of release.
Yes, Your Honor. As I understand, according to bond schedule, bond's like about $500 on something like this. Mr. Joyce is a lifelong resident of Florida, has lived in Orlando for many years, has no criminal record other than, well, his last conviction was for a duelist some 13 years ago. I don't believe he's a flight risk or a danger to anyone. I'm assuming the court's going to impose the condition of no contact. So I'm requesting like an ROR bond. If the court posts, the $500 bond or something, he could make that. But given the facts of the case in the world of domestic violence, I believe he's accused with having pulled his wife's ponytail and that while they were arguing, and so it's not the most egregious DV case that I'm sure the court has seen before you. So I'm hopeful it's going to be resolved some other way. So.
State want to be heard? I assume the victim's not here to present any testimony. Okay.
No.
State?
Nothing from state, Your Honor.
Your Honor, we did qualify Mr. Joyce for straight pretrial release as well.
Where is he going to reside once he gets out?
He has lots of family in town. He's got a brothers, so.
Brother.
Which brother?
Ryan.
He's going to be residing with his brother, Ryan Joyce. You need an address or?
Okay.
He just moved into.
This is
Yeah.
what the court's going to do. I agree the arrest affidavit as far as batteries and domestic violence batteries go, it's, on the lower level as far as the contact and what happened and so on. Obviously, the victim felt compelled to call the police, so I would assume it was a little bit more than flicking of the hair, which I think was the way the defendant called it. But based on everything I've seen, what the court's willing to do is set a $500 bond, no hostile or unwanted contact with the victim, at least till further order. The court can only return to the residence once or escorted by law enforcement to retrieve any personal items. And if you want to change that, you'll need to set some kind of bond hearing or some kind of conditions of bond hearing to talk about whether or not a different judge was willing to make any changes. They probably would want to hear from the victim, though, before they would make any changes to those conditions. No. Well, no, I want officer, if he returns to the scene, to retrieve property. But other than that, and he can't reside there, but other than that, he can have contact as long as it's non-hostile contact and not unwanted contact.
Your Honor, may I just have one moment?
Yes. They can't use the headphones, right?
हेलो
Yes, this is Judge
जी हम
Dawson.
आपसे
We're doing initial appearances, and apparently we have someone whose native language is URDU. I'm not sure how to pronounce that.
हाँ उर्दू
Urdu, okay. This, I'm gonna need to, are you familiar with initial appearances?
एक्चुअली नो
Okay. Well, we're at the Orange County Jail. These are individuals that were arrested in the last 24 hours. I'm Judge Dawson. I'm doing the hearings, and we bring in the inmates one at a time to inform them of what they're charged with and what their bond, if they have a bond. If they don't have a bond, I usually have to set a bond of some sort. So that's what we'll be doing, and of course, I'll try to break it up so that you can translate over the speaker system.
Yes.
Each, as we move along. So.
Yes.
We need Awais Arshad.
That's me.
If you'll state your name for the record, please.
My name is Awais Arshad.
Do you need an
जोर से
interpreter?
बोलिए
Do you need an interpreter, or can you speak English?
Yeah, a little bit. I need it.
Okay, we have an interpreter that's going to be translating what I say. So,
यस
all right.
अपना नाम बताइए
मेरा नाम अवैस अरशद है.
अवैज अरशद
All right, you were arrested on domestic violence battery and currently have no bond.
आपको घर में मारपीट करने के लिए गिरफ्तार किया गया है और अभी आपका कोई बॉन्ड नहीं हुआ है
मैंने कोई मारपीट नहीं की. मैंने घर में कैमरे लगाए हुए थे. मेरी वाइफ ने कैमरे तोड़े हैं. बच्चों को मेरे खिलाफ किया है और उनको माइंड बनाया है. तो उन्होंने मेरे साथ किया जो भी किया.
I did not beat up anyone in my household. My wife broke the cameras that were in the house, and she poisoned my children's mind.
Okay. Well, you should not talk about the facts of the case until you have had a chance to talk to an attorney.
I call it, but
वो जब आप अटर्नी सुनिए अभी आप ना बताइए कि क्या हुआ था. पहले अटर्नी से बात कर लीजिए उसके बाद बताइएगा.
ठीक है.
Yes, sir.
The court has reviewed the arrest affidavit.
कोर्ट ने आपकी गिरफ्तारी का जो एफिडेविट है उसको पढ़ा है.
Anything from the state in reference to bond or conditions of bond?
Your Honor.
तो बॉन्ड की जो शर्तें हैं या बॉन्ड में जो कुछ कहा जाएगा.
He qualified for a straight.
हाँ ठीक है. मैं बॉन्ड क्या करना है. मेरी बेल हो जाएगी आज कि नहीं.
Yes, Your Honor.
Okay.
He qualifies for pretrial release, Your Honor.
All right. Anything from defense before I set a bond?
Judge, he has no.
Yeah, he said, how much is the bond? Shall I be bailed?
He has no history, Judge. I think 500 is appropriate.
$500 ठीक रहेगा.
All right, the court is going to set the bond at $500. No hostile or unwanted contact with the victim. And
आपकी जमानत $500 की कोर्ट ने तय की है और आप अपनी बीवी से कोई भी तरह का राब्ता नहीं रख सकते. उनसे किसी भी तरह से बातचीत करने की कोशिश नहीं कर सकते.
उसी के पास
Yes, Your Honor.
उसी के पास मेरा ग्रीन कार्ड, पासपोर्ट, सोशल सिक्योरिटी, आईडी कार्ड उसी के पास है. और मेरे जो eBay एंड अमेज़ॉन पे मैं काम करता हूँ उसी घर में मेरा सारा स्टफ है. उसने उठा के कहीं और ले गई है, रख दिया है. तो मेरे पास काफ़ी ज़्यादा ऑर्डर हैं. मैंने जाके शेयर करने हैं. तो नहीं तो मेरा बिजनेस फिनिश हो जाएगा.
I work for Amazon and all my stuff is in the house. My green card, my social security card, my passport is in the house. She has put it someplace else and I have some orders to deliver. If I don't do that, my business will be over, finished.
Well, you can return to the home once escorted by law enforcement to retrieve your personal items. I can't,
वो
go ahead.
वो कि- आप किसी पुलिस वालों के साथ जाकर के अपना सामान अपने घर से उठा के ला सकते हैं.
Okay, thank you.
All right.
Thank you.
Thank you very much. And
शुक्रिया.
that's all that we need the interpreter for. Thank you very much.
So, Your Honor, that's a no
You're
hostel, but
welcome, sir.
maintain separate residence?
Yes.
Okay.
Yeah. Need to go review the rest of the Orange counties. All right, we're going to take a break because I need to go review the remainder of the Orange counties. If y'all want to have a conversation about the no bonds or any of them that they're going to ask to reduce bonds, it would help so we can try to speak through those if we can. Just to let you know, what I normally do is when I read the no bonds, especially domestic violence, I make my own notes just from the facts in the, state your name.
Jelani Kyle Cox.
All right, you're here on two separate cases. The first one is the domestic violence. Count one is a burglary of an occupied dwelling with an assault or battery. Count two is criminal mischief between 200 and 1,000. Count three is tampering or harassing a witness. Count four is resisting an officer without violence. Count five is a battery. Count six is a tampering with witness to hinder communications. And based on those, there's also a VOP filed. The VOP has no bond, and that would remain no bond until you see the judge who has you on probation. As far as the other charges, my understanding there was a challenge as to count one.
Yes, Your Honor. My argument is that count one should be charged as burglary of a dwelling, which would be an F2 by itself. The alleged battery, if we take the facts as true in the affidavit, occurred prior to any burglary.
State?
State concurs, Your Honor.
So you believe if that was a burglary as opposed to a burglary with an assault, that would be a burglary of residence, which would be an F2. I'm not sure it's going to matter a tremendous amount because of the VOP, or at least until that's resolved, but the court will set a $2,500 bond on that count. Stay the rest of the other bonds that were set, but on count three, one was not set. I'll set a $1,000 bond, and on five, it was not set. I'll set a $500 bond. So he now has a bond on all counts except for the VOP. And if he does bond out on the new charge, no contact with the alleged victim, and no return to the scene. Thank you. Michael Page.
That got set. So the only one that's no bond is the VOP. The rest got set. You're good.
State your name.
Michael Page.
All right, you are here on a aggravated battery with great bodily harm, domestic violence. do we have is there a victim on this one, or do we? Okay, just want to make sure. Anything from the state before we set bond and conditions?
No, Your Honor.
Anything from defense?
Judge, my position is that this charge is more appropriately a simple battery. I thought that the affidavit didn't really show any proof of great bodily harm. But as to bond, I see that he does qualify for pretrial release based on this paperwork. So I'd be asking either for PTR or a reasonable monetary bond.
Okay. Court is going to set a bond of $2,500. No contact with the victim, can return once to retrieve any personal items escorted by law enforcement. And Robert Turner. State your name.
Robert Turner.
All right. You're on an aggravated assault, domestic violence. You originally had no bond on that. Anything from the state before court determines bond?
No, Your Honor.
Defense?
No, Judge.
Is this a victim or a witness? State your name, ma'am.
Tasha Webb.
Okay. And there's something you wanted to say to the court about the either setting a bond or conditions of bond?
No, they told me to come up here because my niece was the one who made the aggregation
Right.
on him. So they told me to come up here and to speak on the fact that she's having, mental problems and stuff like that, so y'all would know.
Okay. Now, does your niece live with you?
Yes, I got custody of her because she was having problems. The same problems is the one she was having in Chicago. I moved her down here with me.
Okay. And was Mr. Turner living with you?
Yes.
Does he have somewhere else to live while this case is worked out?
Well, she's no longer, she's at my sister's house until DCFS closed the case out.
Okay, so she's not, were you her legal guardian or?
Yes, I'm her legal guardian now.
Okay, so DCF moved her to another relative?
Yeah, they put her at my sister's house because the accusation she was making on Robert, but then they found out she was lying. So until they closed the case, she was put at my sister's house.
And do you care whether Mr. Turner comes back to your house?
Yes, I want him to come back home.
Okay, you understand that if he comes back there, your niece can't have any contact with him, or he can't have contact with your niece.
Right, until
That's
the
by
investigation
phone or in
is
person,
over.
because if he does, they'll put him back in jail with no bond.
Right.
Okay, well, I'm still gonna set the $2,500 bond, but no contact with the victim, but as far as I can tell, he can return to the location since the victim's no longer residing there. All right, thank you. Is that, so we just want to reset it tomorrow and see if he's out? And Lamont White, state your name.
Lamont White.
Right, you're here on an aggravated battery on a pregnant person. Do we have a witness here or not?
Yes, we do.
State your name.
Erica Lanier.
And you wanted to be heard on Mr. White's situation as far as getting out of jail and what kind of conditions would be put on that?
Yes.
What do you want to say to the court? What would you want to say?
What do you mean?
Well, you said you wanted to give some information about whether you think he should or shouldn't get out, what kind of conditions
Well,
should
I
be
do
put on
want
him if he
injunction.
can get out?
I do want an injunction. So, because I see the situation is just gonna get worse, and I am pregnant with his child. I don't want any contact with him whatsoever or his family. Um, and there's, a situation, um, that pretty much, started the argument yesterday. And the police officers, they're investigating that situation as well. And I don't want to have anything to do with him. I do want to know, moving forward, whether he is going to get out. And that way I can, protect myself and my children and also, my family and do what I need to do. So.
Okay. Does the state wish to ask any questions?
No, Your Honor.
Defense wish to ask any questions?
No, Judge.
All right, state want to be heard on either bond or conditions of bond?
No, Your Honor.
Defense?
Judge, he does qualify for pretrial release, and he has no prior felonies.
And let me ask the witness, does he still have property at your house that needs to be retrieved?
I do have property there, yes, that needs to be retrieved. My work items, stuff, my kids, they have stuff there too. And
Okay.
I was told by the officer, I could contact the emergency number that I was given yesterday and call them, to be there because I didn't want to go in the house, by myself or, with a family member.
Well, who owns the house, or is it rented?
It's rented through. I'm assuming his name is on the lease. So
Okay. Do you know what your client is going to do if he can get out? If he's going to want to go back there, or is he going to find somewhere else to live, or what?
I'm not staying there. So
Oh, you're leaving?
yeah, I'm staying. I gave my address to where I was residing.
Okay, do you still have stuff there, or you already?
Yes, I still have stuff there though.
Are you going to remove your stuff?
Yes.
How soon is that going to happen?
I wanted to do as soon as today. I do have a package coming in on the 13th, and I also, notified the officers about that as well. So.
Okay, so after the 13th, which is Monday, you shouldn't have any reason to be there?
Correct.
Okay, so if he was prohibited from going back there till after Monday, even if he gets out, you would be gone and you wouldn't cross paths?
Correct.
Okay.
Or anyone who's affiliated with him, like his family, his brother, like the whole nine. Like, I don't want nothing to do with him.
Well, just to make sure you understand, I can prohibit him from having contact. I can prohibit him from having contact through third parties. In other words, I can prohibit him from having one of his family give you messages or harass you.
Yes, I would like that.
But I can't, I don't have any control over them because they're not charged with a crime.
Yeah.
So if they do harass you or they do something that is a crime, like, threaten you, push you, do something, that has to be handled through either law enforcement or some kind of injunction. I can't order his family not to harass you.
Yeah.
I can order him not to have anyone harass you or even pass messages, whether they're harassment or not, through third parties. So even if they just called to say he's sorry and, hopes you don't testify against him, that would be a violation of his release.
Right, yeah.
All right. Well, what the court is going to do, I am going to set a bond of $2,000, no contact with the victim, no return to the location till after the 13th if he gets out sooner than that, and no communication or contact either directly or third party with the victim. So if there's something that you need from the victim, like property, or you think she took something that you need to get back, you need to go through your attorney or law enforcement to try and get whatever that is or any message you may need to pass to try to get something back. Now, let me also let the victim know, it's my understanding that you are carrying his child, correct?
Yes.
Okay. Well, he does have some responsibility to support you and the child through your pregnancy. So if
I
he
don't wanna
chooses to do that monetarily, there needs to be a way for that to be set up.
Okay.
So you just need to be aware, he can't directly talk to you
Yeah.
or communicate with you, but he certainly, if he wishes to monetarily support you and the unborn child,
Yeah.
can do that through third parties as long as it's solely for the purpose of that, not to talk about this case or not to get you to do something or not do something. Okay?
Well, yesterday in the situation, he did mention that he didn't want anything to do with me and the child. So I'm gonna take his word for that.
Okay.
And
That's his
I'm-
choice, but legally, if he wants to support his child, he's supposed to.
Okay.
If he
yeah.
chooses not to, that's a different question. But
Okay.
if he chooses to do it, there should be a way, there has to be a way for him to be able to do that, but he doesn't have to do that by communicating with you.
Okay.
Okay?
Understood.
All right. Any other questions?
No.
All right. Thank you. James Bolden. State, James Bolden, step up and state your name.
James Edward Bolden.
All right. And is this a witness for this case? State your name.
Ethan Robinson.
All right. And this is, you're charged with a domestic violence battery. There's currently no bond on that. Court will set a bond on that. I should mention up front that apparently he's already ROR'd on a felony case based on I think it was the state not filing within the time frames, so he was ROR'd because they're fairly serious charges. My understanding, are you the victim in the case?
Yeah.
And you wanted to say something to the court?
I mean, not really. I mean, he can get out if he wants to. It don't matter.
What about contact with you if he does get out?
It doesn't matter. I don't really.
Well, that didn't give me a lot of information saying
I mean-
it really doesn't matter. Do you think that's a good idea, bad idea?
I mean, where we live at now, I won't be living there for long, so that's what I was saying.
So
It's a good idea.
whose name is that place in?
Up under my cousin.
Oh, okay. So that isn't yours or his?
Yeah.
place. And you plan on moving out?
Yeah.
And do you want to have any contact, or do you want an order saying he can't have contact?
I mean, no contact, I guess.
Okay. State want to be heard?
No, Your Honor.
What about the case he's out on ROR for? Has that been filed on?
No, Judge.
It's been 3 months. Is the state planning on filing on it?
I actually don't have any information on the other charge, if you'll give me a minute on it.
I know, I've been subbing in a criminal division the last 2 weeks. Apparently, this is a pretty common event now. Used to never happen or rarely happen. So I wasn't sure whether that was just, they take that long to file, or if those are cases they're never going to file on, and that's why the time runs. I mean, would you have any way of knowing that from your computer as to why it still hasn't been filed on 3 months later?
No, and they don't, unfortunately, they don't give me a case number.
I have the case number.
You have the case number?
Yes, it's 2021 CF 1207480.
Your Honor, they're waiting on FDLE results.
For 3 months?
FDLE is very, very backed up.
And Judge, I see the notice of non-filing from October, and there's a checkbox for other information needed, but there's no checkbox for lab report needed. So,
Well, I mean, clearly this is not a drug charge today.
Right.
And I can't really determine whether the state is ever going to file. I mean, there was a lot of other charges, looks like, that could have been filed if they wanted to. So I'm not going to revoke his ROR on that case. I will set a $500 bond on this case, no contact with the victim. You can return once to the place of residence, escorted by law enforcement to retrieve any property you may have there if you do still have property there. And let me just let the victim know, if for some reason you change your mind and want to have some contact, you need to let the state attorney know, because if you and him just decide on your own you want to start having contact and somebody finds out about that, they'll put him back in jail on no bond because he violated his condition. So if you do change your mind at some point, you can't just say, okay, I've changed my mind, let's talk, or let's see each other. You got to let the state attorney know so that, or his defense attorney, he can let his defense attorney know that you've changed your mind for some reason. But he shouldn't know that because you're not supposed to be having contact. You understand all that?
Yeah.
All right, thank you. Edith Gilkey,
Yes, sir.
state your name, please.
Edith Lynette Gilkey.
And do we have any witnesses on, I don't see anyone coming in. You've been arrested in on no bond on a battery, domestic violence. Anything from the state before the court determines bond or conditions?
No, Your Honor.
Defense?
Judge, we'd be asking for a $500 bond. The alleged victim is my client's adult daughter, and it appears she didn't wish to fill out any information or a statement. Don't believe she wishes to prosecute.
All right, court would set a $500 bond in order no hostile or unwanted contact. What that means is you're allowed to have contact, but if it turns aggressive, that's a violation of your bond. Or if your daughter says, I don't want you around, or I don't want you here, or I don't want to talk to you, don't call me. If you call her or talk to her against her will, that's also a violation of your bond. You understand all that?
Yes, sir.
All right, thank you.
Thank you.
Brian Jones. State your name.
Ryan Jones.
You're on domestic violence battery, originally had no bond. Anything from the state for the court determines bond?
No, Your Honor.
Is this the victim?
Yes, ma'am.
You'll state your name, please.
Mrs. Saunders.
And you wanted to say something to the court about this, either his release or conditions of release,
I think he
or,
needs time to dry out.
excuse me, what?
I think he needs time to dry out.
Okay, and so you don't want contact with him until he's dried out?
I don't think he wants to have contact with me either. I mean, you don't push people down on the ground that you want contact with.
Okay,
I think he needs to be responsible and do what he needs to do and get some counseling, because he's got my world all flipped upside down all the time, because I don't never know. I don't do nothing right. He wants me one day, and then 3 days later he's waking me up, sending me down the road injured. I got hit
Now-
by a car, there's third parties out in the neighborhood that try to run me over. I'm not safe. because
Now,
the
you
people
don't
that he
live
associates
together,
with.
right?
I'm sorry?
You don't live together.
Not no more, we don't.
Okay, so you have a separate residence.
Yes, but in my neighborhood where I grew up, where I live, he associates with third party, not favorable people.
Okay, well,
that-
if he gets out, if I give him a bond, the court's order would be no contact with you, and that means third-party contact, contact through friends, contact by electronics or phone, and if he does that, it would violate his release. So, he can't send messages by his friends to you, either to harass you or to try to get you to do something or not do something. But, so, he's got a separate place of residence, and you don't need to be there, and he doesn't need to be wherever you
Well,
are, right?
The thing is he works right beside where I work. And
Well, he just has to go the other direction if he sees you, if you're anywhere nearby. If you come into a place like a store, if he comes in and you're there first, he needs to leave. If you come in after him, he needs to leave. It's, if it's a common area, you have a
Well,
right to be there. He does not have a right to be around you.
Okay,
Okay, you understand?
I also want to add that, I love Ryan very much. The righteous Ryan Jones. I love that man. But he needs to get some help with the drinking and the drugs and the decisions that he makes, because it affects more than just his life. It affected
Okay.
mine.
Well,
And
the only way the court would have jurisdiction to do that is if he's found guilty of an offense, then the court could make conditions of probation. So you just need to make sure the state attorney that handles the case is aware of your concerns and what you think might be appropriate for some kind of
Right,
supervision.
because there's no room in my life for a man that does not fear God.
Okay,
That's all I have to say.
all right. Anything from defense?
No, Judge, he has almost no criminal history. We're just asking for a minimum bond.
Court's going to set a bond at $500 and order no contact with the victim and make sure, sir, you understand no contact means no contact, not through third parties, not through leaving messages, not through any other mechanism
And
until
I'm
the
sorry.
court has changed its order.
I would like to add that, there's the possibility that I'm pregnant. I do believe I am. I haven't been to the doctor yet. But, how could you just,
Okay, well, if you determine that you're carrying his child, we had one other victim here like that. He is entitled to try and support you and his child during pregnancy. That would have to be done through some third-party process and not have contact until the court's order's been lifted.
but that's how this whole thing began, because he told me to come over and pick up some money for medicine, and he pushed me down.
Okay, well, this case will move its way through this court system, and we'll see how it works out, okay?
Thank you.
Thank you.
Oh.
All right. Gabriel Rosado. State your name, sir.
Gabriel Rosado.
And you're here on a domestic violence battery charge. Anything from the state before the court sets a bond or conditions?
Nothing from the state, Your Honor.
Defense?
He has no prior convictions, Your Honor.
All right. Court at this time would set a $500 bond. No unwanted or hostile contact with the victim. What that means is you're not prohibited from having contact, but the victim's entitled to say, no, I don't want any contact, and you would violate your bond if you had contact over their objection. Even if you're together somewhere and they say, I've decided I want you to leave, I don't want you to be around me. If you don't, then you would be violating your release. You understand all that?
Yes, sir.
All right, thank you. Begors, Sinicki. State your name. And you have been charged with a domestic violence battery. I see we have a witness. If you'll state your name.
Grażyna Seneca.
And you're the alleged victim, right?
I'm his mom, yeah.
Okay. And you wanted to say something to the court about his release or conditions?
I don't want to do nothing bad to him, but I would love some help for him. I think so he has some mental issues.
Now, he lives somewhere else, right?
He used to live with me I'm sorry.
I know, you're upset, but I'm just trying to establish, he has a different residence now.
No.
Right? I thought he was moving out. That was
He
part of
moved
it.
1 week ago. I asked him to do that.
Does he have somewhere to go?
I'm not sure. I borrowed him my car, and he promised to give me my car back in 1 week. Yesterday was the 1 week.
Oh, okay.
And when I came home, after work, he was already at my house.
Right.
And I said, how you get to the house? And,
But he's been gone a week, right?
And we had argued. I said, I gave you money to move out. And because I'm proceed his eviction also.
Okay.
But,
So
have fight and
you don't want him in jail, you want him out and getting help, but you don't want him in your house, correct? Okay. Anything from the state?
No, Your Honor.
Defense?
No, Judge.
All right. This is what the court's going to do. I'm going to set a $500 bond, no hostile or unwanted contact with the victim, and you cannot reside with the victim. So you're going to find somewhere else to live. Cannot be living in that house, and if she doesn't want you in the house or coming around the house, you can't go there. If she says you can come for a visit, then you can, it would not violate your release. But if she says, okay, I'm tired, I want you to leave, then you would have to leave. If you don't, it's a violation of your release. You understand all that?
Sir.
And do you understand all that? You have a right to let him come around if you want. You don't have to. If you can talk to him on the phone or communicate electronically if you want. But if you say no, or you say stop, he has to, or he could have his bond revoked. You understand all that? And he can't live in your home. If something changes where you want to let him live in your home, you'd have to contact the state attorney's office so that they can talk about getting his bond conditions changed, okay? All right, thank you.
Sharon, read your email.
Krista Rose, Sofo. I have Krista Rose Sifo.
Krista Sisifo.
Sisifo, okay. You're here on a domestic violence battery charge. I don't think we have any witnesses. Anything from the state before the court sets bonding conditions?
No, Your Honor.
Anything from defense?
Judge, she qualifies for pretrial release and has no prior convictions.
On the domestic violence pretrial release, what are the any special conditions or?
As long as we have a no contact, no hostile, make sure we do. Or we can do pre-trial release.
Well, I would authorize pretrial release. I'd set a bond of $500 for pretrial release. But no unwanted or hostile contact with the victim.
Your Honor, we could do straight pre-trial release because we already did our,
You already did that.
she already met the criteria.
Okay,
for that
so that's
investigation.
fine.
Yes.
I would agree to straight pretrial release, but the conditions are no hostile or unwanted contact. What that means, if the victim says, I don't want to have contact with you, you can't have contact with them. Yeah, if they say stop, I've decided I want you to leave me alone, go away, you can't stay. That'll be a violation. You understand? That includes all contact, including third party, electronic, phone. But if they are okay with it, and as long as it doesn't turn hostile, if it turns hostile, even if it's mutual combat, you're violating your release. They're not, because they're not on pretrial release. Do you understand all that?
I do.
All right,
Yes, sir.
thank you.
Thank you. Thank you.
Appreciate you.
Kaylin Anderson. State your name.
Kaylin Anderson.
You're here on an arrest for grand theft of a motor vehicle. Count 1, possession of cannabis with intent to sell or deliver. Count 2, you have $1,000 bond on count 1, $150 bond on count 2. Thank you. Ernest Code. State your name.
Ernest Cole, sir.
All right, you were picked up on a arrest warrant for accessory after the fact. And this involved a, sure it was first degree. Yes, I read through the whole thing. I would assume it's first degree murder, accessory after the fact.
Judge, it wasn't clear to me without seeing a warrant for anybody else, but it looks like his is an F2.
Your Honor, the charge is accessory of first degree.
Okay, I thought from the facts that's what it was, but I couldn't find anywhere on there where it actually spelled that out. Anything from the state before the court sets a bond?
Your Honor, we're asking for no bond on this case.
Defense?
Judge, my reading is it's a second-degree felony, so he's entitled to a bond.
Let me ask state, what would your arguments be for a no bond on a second-degree felony?
I was contacted by the ASA who's on this case, and she has said she's going to be filing a motion for pretrial detention, but wanted to make sure he stayed at no bond. His warrant is no bond. Your Honor, if you need more, I could call the ASA and find out exactly why. I just have very little information in front of me.
Well, I'm supposed to set a reasonable bond of some sort based on the circumstances at initial
Can I
appearance.
ask for a reset, Your Honor?
All right, well, I will give the state till tomorrow to come up with any additional information that would assist the court in setting an appropriate bond or no bond. So at this point, I will continue it at no bond at least till tomorrow. Give the state 24 hours, or I guess it might, 24 hours in order to get any additional information to the court. So they'll bring you back tomorrow, and we'll see if the state has any new information, and we'll see what bond, if any, the court's going to set. Okay?
Sir.
So, do you put that to me tomorrow. Okay. Christian De Jesus. Okay. James De Jesus, bonded also? Okay. Prince Dofer? Okay. And is this Alex Guzman?
Fernando Guzman. Yes, sir.
Okay. You're here on an attempted burglary of a conveyance. You have a $2,500 bond on that case. And the court's going to stay the $2,500 bond. Thank you.
We have other charges.
Roberto
Oh.
Garcia Tejada.
So, do you want the case number?
Do we know what happened?
What's the case, what's the booking number?
210-28676.
Bonded.
Bonded? Okay.
Yes, Your Honor.
Shanna Greek?
Refuse, Your Honor.
Okay, well, let's try to bring her tomorrow if she'll come. This one we're recalling tomorrow. Melissa Hobdy?
Yes, sir.
State your name for the record.
Melissa Hobdy, sorry.
All right, you're here on a petty theft with 2 priors, so that makes it a felony, and you have a $1,000 bond.
Judge, would you consider PTR if she qualifies? I don't think she was interviewed because it was a warrant request.
Oh, let me see, let me make sure I read what's going on.
Or if she doesn't qualify, just ROR based on the nonviolent nature of, sorry, Ms. Robin.
Well, I'm reluctant to change the bond. I don't have the facts. All I have is a warrant that obviously the judge who read the facts set a $1,000 bond, which seems reasonable for a third-degree felony, especially when it's based on prior similar behaviors, at least twice convicted. So at this time, I'm going to continue the bond at $1,000. You know, if you want to file a bond motion, the judge would then have the information they need. And apparently, is she already in jail on a DUI charge? Or are you out on that?
I was out, sir. I just finished probation yesterday.
Okay. All right. Oh, so you were in the courthouse? Okay, I was reading Orange County, skimmed over. Well, I'm gonna leave it at 1,000 today. I think you need to file a motion with a judge who has access to the actual information on what occurred and what her history is, so that they can set an appropriate bond if something less than 1,000 is appropriate.
Judge, and I don't know if this is maybe what the court is asking, but we have her like face sheet that shows priors, and her only prior convictions are misdemeanors, petty theft, and DUI. She has no history outside of that, and I looked up the basis for the petty theft, and this was originally a notice to appear. It was an alleged theft from 7-Eleven, and the state decided to upfile it, but it looks like essentially the alleged theft was pretty small amount, $83 in cash.
Well, I mean, $1,000 is a reasonable bond for a felony. It also has conditions of no contact with the victim, no return to the scene, and no possession of firearms. So as of today, I'm gonna leave it at $1,000. Thank you.
All right. See if you can get 100.
Gary Hootie,
Thank you.
state your name.
Gary Lee Hudai.
All right, you've got two cases, both of which deal with failures to appear on felonies. And,
I was not notified. I had court.
well,
Didn't show up because I was released
Okay.
on Thursday motion.
probably shouldn't talk about the facts of your case since it's a failure to appear, why you did or didn't show up.
I was never
May have
notified.
some impact on the, whether they can convict you or not of those crimes. But because of your failure to appear, these bonds were set, and so is he out on bond right now?
No, Your Honor, he just has a local warrant for a writ of attachment.
Or, I mean, these are for failure to appear, so obviously it's something he was supposed to be appearing for.
Right, Judge, their felony offenses, one is,
Oh, I see where they are. I got them here. There's grand theft, third degree of a motor vehicle, grand theft, leaving the scene of an accident, suspended driver's license with 2 convictions, and so on. Well, those bond amounts were set for failures to appear. I think the judge that you failed to appear for is the one who needs to modify any bond if they wish to. So I'm going to continue the bond. It's $5,000 on count 1 on each case, $150 for each of the count 2s, and $100 for counts 3 and 4 of the leaving the scene case. So those bonds would remain until a judge modifies them.
you just said him a second ago. You didn't hear him?
Yeah, but I won't remember until I get back to the phone. And then she told us something about the attachment. What is that?
It's usually on child support.
What's the bond on that?
I don't have access to that. I don't, Miss Robin, you don't have any info on the writ of attachment, do you?
So how do I find out?
You'll have to, your attorney can get more information on Monday. We don't have access to a
And
lot of
bond
that
out before Monday.
information till Monday. So unless you can bond out between now and then, they can access whatever information you're trying to get.
So I'm saying for the written attachment, is that a bond or is that,
They all got a bond.
I mean, the one she was speaking about?
Oh, if there was something else, I don't have that information.
But I don't have that information.
So how do I find out? How can I bond out? Through a bondman or what? Is it a hold or is it a,
There's a hold.
so how do I bond out on that?
You'll get information on that writ.
I think usually they set those for a hearing.
Yeah, you have what the hearing.
So you can see a judge to talk about what the writ is about and how you can get out on it.
So I can't bond out on that?
Correct.
You're all set.
All right. Magdala Jean. State your name.
Magdala Faith Jean.
All right, you're here were arrested and are incarcerated on a charge of possession of cocaine, and you have a $1,000 bond on that charge. Thank you.
I don't have any family.
Your Honor, Ms. Jean's asking for ROR or in the alternative PTR. She's not able to afford the monetary bond at this time.
Court's going to leave it at 1,000 for right now. If she's unable to make that, an attorney can make a motion for a reduction if she's still there and cannot make that bond. Oh, okay. Is this James? Okay. Is this James DeJesus?
Yes, sir.
All right. Apparently your co-defendant bonded out. You were picked up on a possession of ammunition by a convicted felon, and they've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19 counts of that, and then carrying a concealed firearm, which is the 20th count, and possession of cocaine, which is the 21st account, and possession of drug paraphernalia, the 22nd account. The first count, they put a $5,000 bond. All the other ones, they have $150 until you get to the very last one, which is possession of drug paraphernalia, and you have $100. Let me ask the defense, is this a case where they charged him with every bullet that was
It
in there?
appears that way, Judge. Although I don't recall any specific facts saying that they even recovered that many bullets or pieces of ammunition. So, because the way it sounded in the affidavit was almost as though they were charging him for every felony that he ever had, but that doesn't match up either. So I couldn't figure out how there was PC for each one of these.
The co-defendant, they had a property list, and it listed a bunch of different ammunitions and so on. So I wasn't 100% sure if that was just what was associated with that defendant or if that was for this, but let me ask State, is that a common practice to charge every bullet in the magazine when it's a convicted felon, or would these all been separate?
No, Your Honor. I mean, it's not the common practice to charge for every round per se. I'm sorry, I passed that.
Well, this is what the court's gonna do. Looking at the other case, there were some different types of ammunition. It wasn't all the same. I understand why they might charge more than one count if there was 9mm rounds as well as, 38 caliber rounds. But I'm going to not find probable cause on all but one of the possession of ammunition counts. So he still will have a $5,000 on the first count, but I will remove all the $150 ones till you get down to the carrying possession of a firearm by a convicted felon. So that would be 1, 2, 3.
Is this Mr. Johnson?
No, this is Mr. Jesus. This is one they said had bonded out, but both De Jesus's had not bonded out, only one. So I'm staying the bond on count 1. I'm
Yeah, I see that, but I have different.
no. The count 1 is a ammunition charge, and it's 5,000. Count 2 through 18, I'm not finding probable cause for.
Your Honor, I'm sorry, but for Mr. De Jesus, the only charges that I have for him are driving with a suspended revoked license.
Which De Jesus are you talking about? James or the
This
other?
is Christian.
Yeah, Christian bonded out.
That's the problem. That's the problem we had up front.
This is De Jesus.
I
mean, this is James De Jesus. So I'm not finding probable cause for counts 2 through 18. I'm staying the bond for counts 1, 19, 20, 21, and 22.
These things got stapled.
So it'd be 5,550 total. Right. All right. Thank you.
Thank you.
You're all set.
Johnny Johnson? State your name.
Johnson.
All right, you're here on two separate cases. On the 21-5717, you have possession of cocaine, count 1, with a $1,000 bond, tampering with physical evidence, count 2, with a $150 bond, resisting officer without violence, $100 bond, and possession of drug paraphernalia, $100 bond. The other case, which is 21 CF 15678, you have sale and delivery of cocaine, count 1, with a $15,000 bond, possession of cocaine, count 2, $150 bond, possession of ammunition by a convicted felon, $150 bond. And then again, we've got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 additional possession of ammunition by a convicted felon. I'm going to ROR on count 4 through 18. And then he's got a $100 bond on 19 for possession of drug paraphernalia. And then you also have 21 CF 15675, which is a possession of cocaine with a $1,000 bond. I think that's got all of them.
Judge, as to count 1 on 15678, the sale delivery, I'm not seeing any facts in the affidavit to support that count.
Well, it's the items that he had in addition to the cocaine that caused him, well, I think you're right. Let me look again.
Yeah. Okay, so.
Probably because of the scale.
Wouldn't that be possession with intent as opposed to actual sale and delivery?
I think it's just simple possession, but yes.
No, I think, well, based on the amount and the scale and the other items that were, the blender, hot pot, pipes, I think the court could make a fine and probable cause for possession with intent to sell, but I agree, I don't think there was any actual passing of or sale of the item.
The kind of overarching issue on this is there's no actual facts suggesting that he lived there, that he, has exclusive control over everything found. I mean, this may not be the venue to assert that.
Right.
But for purposes of reasonable bonds, if the court is finding possession with intent, we just request something around $1,000.
I mean, the affidavit said Johnson is a known occupant of this house.
Well, I think there's clearly probable cause for possession with intent to sell. I tell you what, based on what the court sees, and, I mean, obviously, this was a little more than just having more drugs than for personal use. The court would be willing to drop count 1 on the 21, 1, 5, 6, 7, 8 to 10,000 instead of 15,000. If he wants it lower than that, there needs to be a bond hearing in front of a judge with more information and law enforcement if they wish to come to give information.
I understand, Judge. Thank you. This is good. You're gonna have to double check this.
Got Wesley Cahill. Okay.
So, don't forget that one. Add those up. You're all set.
State your name. State your name.
Wesley Cahill.
All right, you're here on a possession of controlled substance. You have a $1,000 bond on that charge. Thank you.
Yes, sir.
Can you pull that?
Kelton Little. He's what, behavior? All right, so we'll recall tomorrow, see if he's decided he wants to behave. Jaquez Medlock.
Mental health.
All right, we'll recall tomorrow to see if he's available. Vincent Moore. State your name. State your name, sir.
Vincent Moore.
Okay. You're here on a delivery of controlled substance within 1,000 feet of a convenience store business. They set a $15,000 bond on that warrant. Also have a, on 21 CF 12946, possession of a firearm by a convicted felon with a $1,000 bond, possession of cocaine with a $1,000 bond, possession of meth, or MDMA, $5,000 bond, and possession of drug paraphernalia, $500 bond. And at this time, based on the probable cause, the court is going to stay those bonds. So it's 15,000 on one, and then the collective 1,000, 1,000, 5,000, and 500 on the other. Right. The conditions that were set on the original warrant will follow through on the bond conditions.
Judge, would you be willing to reduce the second case, the delivery of the controlled substance, to something a little more reasonable? I understand the allegation, but these are still nonviolent drug offenses, and right now his bonds are totaling $23,000.
Well, I mean, they may have been nonviolent, but he was possessing a firearm by a convicted felon involving one of them. So at this time, the court's not willing to modify the conditions of bond or the amount of bond. Randy Uten, state your name.
Randy Lee Uten.
All right, you're here incarcerated on charges of possession of methamphetamine and possession of drug paraphernalia. Count 1, you have a $1,000 bond. Count 2, you have a $100 bond. You also have another charge on 21 CT 8092, which is a no valid driver's license, and you have a $100 bond on that case. And the court is staying the bond on each of those. Thank you. Christopher Pletka, state your name.
Sir.
Say it.
Christopher Pletka.
Okay. You are here on a new case. You have possession of cocaine, count 1 with a $1,000 bond, possession of oxycodone, count 2 with a $1,000 bond, and possession of drug paraphernalia with a $500 bond. Court is staying those bonds, but apparently you're out on bond on a number of other cases on the 2020-2235, possession of cocaine, possession of drug paraphernalia, on 19 CF 15452, possession of controlled substance, possession of heroin, possession of controlled substance and drug paraphernalia, count 4, on 2019 CF 15768, possession of controlled substance and possession of drug paraphernalia. On each of those, you are already out on bond. The court is revoking those bonds, and that would be no bond until a judge establishes a new bond.
Your Honor, we also have a 2020 CF 22030 case that is out on bond as well.
Okay. Didn't have that one, but I'll revoke that bond also.
2020 CF 22030.
Oh, I think I stated that one, didn't I? Yeah, I did state
Your
that.
Honor? Oh, I'm sorry.
Yeah. So there's not an
Okay.
additional one.
Okay, thank you.
Marvin Racine. State your name. You're here on a grand theft third-degree motor vehicle charge with a $2,000 bond, a resisting officer without violence with a $200 bond, and the court is staying those bonds.
Your Honor, we did qualify Mr. Racine for straight pretrial release. He has no priors. Well, he is returning back to New York. He was just here traveling from New York. Priors.
Is that Mr. Racine, you said?
Yes, Your Honor.
Because the arrest affidavit says that he's got warrants for burglary dwelling, grand theft. Oh, okay, these were the warrants. No, there's. Is he in on, has he already appeared on other warrants?
No, Your Honor, he's just here for grand theft and a resisting.
I think that was the code.
Is that the co-defendant? You are right, it's the co-defendant, I'm sorry.
That's,
I saw that at the bottom of the. So you're saying he qualifies for pretrial release?
yes, Your Honor.
What's the state's position on that?
her face sheet actually says he doesn't qualify for PTR, so I'm not, I don't have an issue with PTR, Your Honor, because as far as I can tell, he has no other criminal history.
Okay.
It's an updated face sheet, yeah. Your discretion, Your Honor.
Yeah, that's fine. I mean, I'm not opposed to PTR.
All right.
State
Well,
is not opposed to PTR.
What I would do is authorize he can either postpone or he can be released, pretrial release. James Skipper, state your name.
James Skipper, sir.
Here to be, first appearance for a possession of fentanyl. You have a $2,500 bond on that charge.
Sir, I was here on a fentanyl charge and I already got out on it. I already did my time for it.
Well, this is one that supposedly happened in August of this year. I doubt if you've already.
August of this year?
Yep.
I haven't had no fentanyl charges. No.
Well, you do now.
It's a warrant?
They got a warrant and it was signed by a judge and a bond was set. So if you think there's some kind of mistake, you need to talk to your attorney about it. Okay?
Sir.
Barry Summers.
Yes, sir.
State your name.
Barry Summers.
All right, you're here on, I think, two cases. The first one is a possession of MDMA or ecstasy. That is a $1,000 bond, and possession of cannabis, less than 20 grams. That has a $150 bond. And then you also have on 21-15696 a possession of cocaine with a $1,000 bond. And the court is staying those bonds. Thank you.
Your Honor?
Yes.
Is there any way can I request for a little bit lower?
Excuse me?
Can I request for a little bit lower, bud?
Not today, because these were based on warrants that were signed by other judges, so they've got more information about the facts than I do. And once, your attorney can file a motion to reduce it if you can't get out on those. Yordany Zamora. State your name.
Jordani Zamora Garcia.
All right. This was kind of an odd set of facts.
Yes, Judge.
Trying to figure out, is this alleged victim, does he live in your apartment complex? So if you return to your apartment complex, is he going to be there because he lives there? What makes you think he won't be there?
He cannot come out from jail. This is what I was told by my bail bond, because he was already out on bond, and so he violated his.
So is he in jail? Okay. State have any suggestions on bond or release conditions? It's really kind of hard to sort through who was the person at fault here.
Oh, Your Honor, I believe he is on our docket. Is it Benavides Aquila?
Is he on our docket?
I believe I saw that name. Let me double check. I thought.
Because I don't remember reading another arrest affidavit with the same facts.
I don't remember seeing it.
I saw it somewhere.
There was, Benavides, who is on our Spanish interpreter list, was also arrested, but
But was he went arrested for this situation? What was he charged with?
Let me pull that up, Your Honor. I can get that for you. He was given a $10,000 bond.
Yeah. But the other guy, Gonzalez, right? Yeah, Gonzalez was not arrested, and appears to not even live there. I mean, frankly, I I have concerns about, I mean, I think Ms. Zamora was probably justified in her use of force. I mean, taking the facts as they are, there's multiple accounts of Gonzalez with a firearm walking around.
He was out on bond too, so.
Apparently, he had another bond revoked, so he's probably not gonna be out for a little while.
How high it is.
Okay, yeah, the way it's written, other than if I'd have noticed the names, it wouldn't have automatically clicked. It was the same events. Well, this is what the court's gonna do. First of all, you know, just as a side comment, and you shouldn't say anything about the facts themselves, but, you know, anytime people are waving around guns, bad things happen. And you may have a defense. It seems to be a big discrepancy between the witnesses as to who did or didn't have a gun and what they did with it. What the court is going to do is I'm going to set a bond of $2,000, no contact with the victim, and no possession of firearms. So I assume if you had one, it was yours and you need to get rid of it, somebody needs to take it somewhere else while this case is pending, unless a judge in the future changes. No, just no possession of firearms. You know, you need to make sure if you have any, that they're removed from wherever you are, that nobody else has one around you, and then no contact with the victim. Apparently, they may have no contact orders on you, so that nobody should be having contact with each other. And so set a $2,000 bond, no contact, and no firearms. Thank you. Willie Montanez.
Yes, sir.
State your name.
Willie Montanez.
All right, you were picked up on a failure to appear on a leaving the scene without giving information. The judge who issued that set a $2,000 bond, so I am keeping it at $2,000. The judge who issued it is the only one, or it will not be reduced probably until either that judge reduces it or they see you. All right?
Got a question. I was here while I don't understand how I got an FTA when I've been incarcerated this whole time.
Okay, well, you need to talk to your attorney about that. They could probably determine if that's true, then the judge will probably set aside the failure to appear if you really were incarcerated. Normally, they check the jail rosters, but that doesn't always happen. I know for a fact that mistakes are made. So, but you need to let your attorney know so that they can research that, and if that turns out to be true, they may be able to get you out.
Your Honor, I have him, I think
No,
some of
this
the,
is an add-on. It's an add-on charge. He's here on other charges.
okay.
Yeah, he was already seen on that. Yeah.
Which is probably why he didn't show up. He was in on other charges now. Mark Chapkus? And Nelson Figueroa? State your name.
Nelson Figueroa.
You were picked up on disorderly conduct, count 1 with a $100 bond, and possession of drug paraphernalia, count 2 with a $500 bond. And my understanding, these are pleable misdemeanors if the state wishes to make an offer.
Your Honor, as to count one, state would like to announce a null pros.
So he can be ROR'd on count one.
I'm sorry?
I said he can be ROR'd on count one since you're not
Yes, Your Honor.
intending to move forward. What about count two? Do you have an offer or you just want to leave the bond at 500?
Or can we ROR
Well,
count two?
I have no issue with ROR on the second count.
Do any of these qualify for pretrial release?
No, Your Honor.
Okay, just want to check. Well, based on everything, if he's not going, if you're not going to make an offer today, I don't have a problem reducing it to $100 bond, but I don't think I'm going to ROR it based on a disorderly conduct and possession of drug paraphernalia, even though they're dropping the disorderly conduct.
Just so you know, Judge, the disorderly conduct was essentially what appears to have been attempted panhandling. So I don't know that $100 is really going to be different than $100,000.
Well, if he can't make a $100 bond, then somebody needs to file a motion in front of a judge to establish that he can't do that.
I can take testimony.
Well, today, whatever testimony might be presented, I just have a concern based on the facts, RORing. Because then you're going to have to expect us to try, he's a transient. Where are they going to notice him to come to court? I mean, if he posts a bond, at least they have $100 of somebody's money that would go get him if he has to come to court. So at this time, I am going to leave it at I'll reduce it to 100. I'm striking count one, or ROR in count one, reduce count two to 100. And maybe you can get the state to be willing to make some kind of offer to get him out. All right? Thank you.
What I gotta do? So first count is already done, and then you
Michael Eden.
He bonded, Your Honor.
Okay. Deshaun Jones.
Here.
State your name.
Deshaun Jones.
All right. You were picked up on a retail theft and a trespass on property after warning. These, I don't know what the current policy of the state attorney's office. I know in the past they wouldn't make offers on victim crimes because they hadn't contacted the victim. Is that, have you changed that policy or? Is that?
No, Your Honor, we haven't.
Okay. Defense, anything else from the state?
So this appears to be a first-time petty theft. We would offer PTD on the petty theft. The trespass would be a withholding court cost.
Could we do a withholding court cost on both?
We could do a withhold, court cost, and impulse control class. 6 months supervised probation, no return.
He's a transient. I don't think probation is really in the cards. So either it needs to be a time served in court cost or.
I How many days has he been in?
He just got arrested yesterday.
Two.
That's why he's, oh, 2 days? So he's got 2 days in. Apparently, it was a can
We'll do
of-
withhold court cost and credit for time served.
Okay. Apparently, it was a $2.50 Miller High Life beer that was removed. Don't know whether it was returned, unopened or not.
No.
Yeah, year to pay. Okay. What is the cost
Okay.
total? So is he willing to enter a plea?
Yes, Judge, I have a signed plea form here. May I approach?
Yes. All right, just need to ask you a couple of questions before I can accept your plea. Do you understand what's going on?
Yeah.
And you understand what the plea offer was, is time served in court cost if you were willing to enter a plea to, is that as to both counts?
Yes,
Yes,
Judge.
sir.
Okay, as to both counts. And did you go over this plea form? You understand the information that's in it?
Yes.
And you do understand that you would normally be entitled to a trial before I could find you guilty or enter any kind of sentence, but by entering this plea today, you won't have that trial, and I'll go ahead and enter the sentence of time served in court costs. You understand that?
Okay.
All right. And I assume defense will stipulate factual basis based on the sworn affidavit for purposes of the plea.
Yes, Your Honor.
Based on the sworn affidavit in court file, will find a factual basis for the plea and would accept the plea and would enter a sentence of 2 days in the Orange County Jail with credit for 2 days you've already served. You'd have court costs of $273, and you would have 1 year in order to pay that. And if it's not paid within that year, I would order it reduced to judgment. Any other questions?
Oh, no.
All right, so you would be released today as to this charge. I don't know if you have anything else that's holding you, but if you would be released as to this charge, and you have 30 days to file any kind of appeal. Thank you.
Okay.
Jerry Warren, state your name.
Jerry Warren.
All right. Does the arrest affidavit was a little confusing. It says that they came in contact with him yesterday, and there were charges filed on him for battery that occurred the day before.
Your Honor, could we reset this? I've actually put in a request for additional information on this case.
Do we show anything? Where would, there's an original report number.
Yes, Your Honor. I mean, I've tasked the sheriff's office to provide me a copy of the
Well, let's, first of all, he is out on bond on 3 other cases, which if I find probable cause, I'm going to have to revoke those bonds. And I'd rather not do that if
Yes, sir.
this new thing isn't really a thing. So what I'm going to do is I am going to give the state 24 hours in order to get me the information in reference to this battery. If, just to let Mr. Warren know, if I find probable cause for a battery, then I would revoke your bond on the other 3 cases, and you would have no bond until a judge set a new bond or they were resolved. If they can't come up with some information between now and tomorrow that convinces me there really is a battery charge out there somewhere, then you would have to be released. You'd still be on bond on those other 3 cases, but you'd be released as to this case until they found that battery charge wherever it is. You understand all that?
Yes, sir.
So we'll bring you back tomorrow. We'll see if they've been able to straighten it out. If not, we'll move forward however is appropriate. Okay?
Guess we have another night in here?
Yes, one more night, and then depending on what they bring me tomorrow, you may get out or you may be in on no bond on 3 other cases, depending on what they get me tomorrow. Okay?
All right.
Shanti Chang,
Yes, Your Honor.
state your name, please.
Deshante Malik Chang.
Okay, you're here on 2 separate out-of-county warrants. They're, look like they're from Okaloosa County. Yeah, Okaloosa. There is no bond on both of those warrants, so you would need to be held with no bond until they send you back to that county. And hopefully they'll get you out of here and there. They usually don't like to keep people for other counties any longer than they have to. All right?
Okay, is there a time on when they'll come?
72 hours. They usually have 72 hours, yeah.
All right,
Yeah.
thank you.
And I have appointed the public defender for purposes of your detention here, so if for some reason you're still here on the, more than 72 hours, contact the public defender's office. They'll have an attorney look into it and see why you're still here. Once in a while, there might be a hold from somewhere else. There might even be a new charge here that we don't know about today, so it is possible that for some reason you could be held longer than that. But contact your attorney if you're here more than 72 hours.
Okay, Your Honor.
Benslov Dormius,
Sir,
state your name.
Benslav Dummers.
All right, you're here. You were picked up on an out-of-county warrant from Lake County. There's no bond on that warrant, so you would need to be held on no bond until you're sent back to Lake County.
I
Hopefully,
have
it'll
one
get-
question.
what's,
I had, they had give me, what was it, a warrant because I was driving a suspended license, but I had fixed my license 6 years ago. It's valid as right now and last night.
well, that's in Lake County, right?
Yes.
See, I can't fix that. This is Orange County. The only thing can fix it is for you to go back to Lake County and let them, tell them whatever your story is and see if you can't get it straightened out. Thomas Farhat? State your name.
Thomas Farhat.
All right, you were picked up on an out-of-county warrant from Brevard County. There's a $2,000 bond on that warrant, so if you can post a $2,000 bond, you can get out until they give you notice when to show up in the other county. If you actually have 2 warrants. The same. Okay, all right, so it's just one with $2,000 bond. If you aren't able to post the bond, they'll send you back. All right, thank you. And Sikta Fuller? Bonded? Okay. And Amanda Gooden? All right, we'll bring it back up. Yeah, and we'll set it within 24 hours of release from the hospital, but this is an out-of-county warrant from Brevard, so they may ship her straight from the hospital back to Brevard, I would assume. But if she's still here, let's have a initial appearance within 24 hours of getting out of the hospital. Darenika Henderson, is that you? State your name.
Darenika Henderson.
All right, you were picked up on an out-of-county warrant from Seminole County. There's no bond on that warrant, so you'll need to remain in custody till they take you back to Seminole County, which should be within the next day or two. I mean, it's supposed to be 72 hours, but they should get you back there. If for some reason you're not taken back in that 72-hour period, contact the public defender's office and find out why. Once in a while, there are other reasons why they might not release you within that time frame.
Okay.
All right? Thank you.
Okay.
Earl Brown?
Okay. No, I gotta give it back.
Yes, sir.
State your name.
Earl Edward Brown.
Okay. Apparently, were you at IA's yesterday? Were you arrested yesterday?
Yes, sir. I was arrested yesterday.
Yeah, that bond was posted, Your Honor, but then they had added on a violation of probation.
Oh, so he was arrested yesterday for the
Yes.
charge and he posted a bond,
Right, correct.
but that violated his probation. So you're in on no bond on the VOP.
Yes, a 5-day hold in place.
Right, it's an on view. So you had no bond on the VOP on view. You probably should have waited on posting your bond on the other one until you were out on this one, because you're not getting any credit on that one. And this is a no bond until the judge who has you on probation sees you, or sets a bond on it.
He has a 5-day hold in place for that violation of probation.
Okay, so you're currently being held on no bond on the VOP. How do they do that?
Well, Your Honor, we give DOC 5 days to issue the actual VOP warrant. After those 5 days are up, if they have not responded, we release that 5-day hold.
Okay, so
Okay.
what, is he automatic released at 5 days, or does he come back before the IA judge?
No, we're addressing the VOP now, but we have the 5 days after that. So once the 5th day comes, if they have not sent any VOP, then we release them.
Then you release him?
Yes.
Okay. So
It's a
they only
5-day.
will hold you 5 days unless they get the VOP
They may issue a warrant. They may
warrant.
issue a warrant, yeah.
If they do that, then you'll be held on no bond until you see the judge, but that'll get the wheels turning on the VOP. All right, thank you. Joseph Crenshaw, state your name. All right, you're here on 2 VOP violations.
Next Thursday.
This is the same situation that were on view arrest, that they've got 5 days, is that correct?
Correct, and he does
Okay.
have a 5-day hold as well.
All right, so you've got 2 separate probation cases because of your other arrest. There's a 5-day hold for them to file VOPs on you, so you cannot be released during that time frame. There's a no bond. If they do not file something in that time frame, they will release you. Doesn't mean they won't file something later, but it does mean you would be released on these cases if they don't file it in 5 days. Oh, wait a minute, okay, and you also have the underlying misdemeanor case, which is a retail theft with a $250 bond. But there's no reason to post that until the VOPs are, because you won't be getting credit on that if you bond out on it. All right, thank you. Gregory Foster. State your name.
Gregory Foster.
All right, you were picked up on a VOP warrant with no bond, so you would need to remain no bond until you go before the judge or that judge changes your bond status. All right?
And Your Honor, he also has a reporting requirements. So once he gets released from the jail, he does have to report his address to the local authorities and Department of Motor Vehicles.
Okay. So you understand that? Once you're released, you have to report?
Yes, sir. Sir, can I speak?
Well, you can if you want, but there's nothing I can do about it. I wasn't the judge who has you on probation. That judge signed a pickup order on a VOP with no bond, so I can't change that. But if you want to say something, but I would advise you probably be in your best interest not to.
Yeah. I'm sorry. He's not gonna, there's nothing he's gonna do to change it. I do.
That should be spoken.
The judge on your case? I can't answer that. I don't know. Good luck.
Lawrence Oliver, state your name.
Lawrence Oliver.
All right, you've got quite a few cases here. Some of them are VOP, some of them are original. The 21 CT 8091 is a driving with license suspended or revoked. You have a $500 bond on that case. You've got on 21 CF 14359, you've got burglary of a dwelling, count 1 with a $5,000 bond, grand theft, count 2, dealing in stolen property, count 3, false verification ownership of secondhand dealer, count 4, and receiving money from pawnbroker under false verification, count 5. All those have a $120 bond on them. You also have on 21 15654, count 1 is a grand theft third degree with a $1,000 bond. Count 2 is a resisting officer without violence with a $100 bond. And you've got a violation of community control on 20 CF 6150. And, correct? Oh, I'm sorry. I got that one. Must have hooked onto the paperclip. So you do have 2 violations of probation, one on 12 CF 695 and one on 12 CF, oh, they're both 6, they're just, so only one, which is a violation of probation. Okay, so there is a violation warrant with no bond. They also arrested him on the on-view for the new charge, which would modify the VOP with an additional count. But the bottom line is, I'm staying all of the new bonds, and you have no bond on the VOP until you see the judge that issued that warrant. Okay?
Yes, sir.
All right, thank you. Antonio Ubilis, state your name.
Tony Ubilis.
All right, you're here on a violation of community control. That was, that warrant has a bond of $5,000 on one count and 250 on the other count that you were on probation for.
Still got.
And so the court is staying those bonds, so total bond is 5,250 on the VOP.
You're gonna be sitting on the VOP anyway. So you're all set. I think 2,000.
Peter Woods. State your name.
Peter Antonio Demetrius Woods.
All right. You've got two new cases. One is the 21-15672, which has possession of firearm by a convicted felon as a count 1 with a $4,000 bond. Carrying a concealed firearm, count 2, which is a $150 bond. Possession of ammunition by a convicted felon, $150 bond. And resisting officer without violence, $150 bond. You also have on 21 CF 15620, an aggravated stalking with credible threat. You had no bond on that. The court is setting a bond of $20,000 on that with no contact with the victim. And then you have a VOP that has a warrant that was issued